Thank you, Sir Frank, and thank you, Dame Rosalind. Your Excellencies, ladies and gentlemen, good evening. I first met Arthur in 1988 at a lunch that he hosted for the Chief Justice of Hong Kong. I was a law lecturer at London University, specialising in Chinese law, and I presume that was why I was invited out of the blue. So there I was, seated next to Mr. Watts, as he then was. So I asked him, well, what do FCO legal advisors do? And really that was just out of polite conversation, not because I had any particular interest in being one. But his answers led me to ask more questions, and, well, how many women are there in the legal advisors? Well, how many women at senior level? Why so few? What do you think should be done about that? Well, not only did he survive my interrogations without seeming to mind it at all, but he even made a comment later on, probably by dessert, I should think. He commented on the decor. He said he thought it was rather, that the mahogany and the dark leather was rather masculine and old-fashioned, and he thought perhaps they should choose a different restaurant in future. Well, I was rather impressed by this because, honestly, I hadn't noticed the decor. And it hadn't occurred to me that there might be a gender perspective in that. So I thought it was impressive that a man in his senior position would make the effort to try and see how the surroundings might look from the point of view of somebody who was very different from himself and very much less important. And as I later discovered, that ability was one of the things that made him an outstanding diplomat as well as a delightful man to work for. And so I have Arthur to thank for my 20-year career at the Foreign Office, the first 2 years of which were his last 2, because it was those conversations with Arthur during that lunch that made me decide some months later, when I happened to see an advertisement for a vacancy at the Foreign Office, that I'd like to apply for it. And, well, I got in. I wasn't disappointed. He was an intellectually inspiring mentor. He was kindly and supportive towards his junior staff, and he also had a mischievous sense of fun. As we discovered one day during a long and arduous negotiation in which there was one delegation that was intent on sabotaging the whole deal. So before the meeting, Arthur arrived early in the meeting room, and he took the bottle of sparkling water that was, I think it was sat on the table in front of the other gentleman's seat. And he picked it up, gave it a jolly good shake, and he put it down again. And he went and sat in his own seat. So when the meeting began, Arthur picked up his own bottle, and he very deliberately, I'm not going to do it now, but he very deliberately unscrewed the top. He poured himself a glass of water, and he slowly started to drink the water, all the while eyeballing the other gentleman. And it worked. The other gentleman followed suit. He opened his bottle and it exploded, and he was absolutely drenched, to hilarious laughter from the British delegation. Well, it didn't change the course of history, unfortunately, but it did give us some light relief in a very tense negotiation. So for all these reasons, in addition to his very distinguished reputation as an international lawyer, it's a very great honour and a very great pleasure for me to be the first person appointed to the fellowship created in Arthur's memory. And I'd like to tell you now a little bit about the Arthur Watts programme that we're developing in international law at the Institute. One of the primary aims of the Watts programme is to combine clear conceptual analysis with knowledge of how international law works in practice. An example of where I think this approach is needed is in examining how legally binding rules and obligations interact with other kinds of norms based on political commitment, moral integrity, or economic imperative. Now, one of the challenges of international law is that it's not always easy to tell the difference between a legally binding agreement and a non-binding one, even if you're an international lawyer with the Vienna Convention on the Law of Treaties in your hand. Governments can get it wrong, as Bahrain discovered when its foreign minister signed a document with Qatar thinking that it was just an informal minute of a meeting, but the International Court of Justice ruled later that it was in fact a treaty. So there's nothing fundamentally new about this problem, but it is getting more difficult and a lot more interesting. So much so that Harold Coe made this the central theme of his recent lecture at Georgetown University on 21st century international lawmaking. There's no doubt that there is more international rulemaking than ever before, and that there's a wider range of participants involved in the process, not only states. So just to mention a couple of well-known examples, since the Kyoto Protocol, international action on climate change has been driven forwards by summit accords, by ranges of public-private partnerships and NGO pressure. Emerging standards of corporate social responsibility and the UN Ruggie principles are now shaping the application of international human rights standards to multinational companies. Sometimes these codes of practice, declarations and guidelines can play a more important role in influencing behaviour across borders than binding rules. So, as academic and practising international lawyers, we do of course need to be aware of that and be involved in the creation of these other types of standards. Some people are arguing that the distinction between legally binding and non-binding at the international level isn't important, or is less important than it used to be, at least where there isn't any international enforcement mechanism, which is most of the time. An interesting example of this line of debate is in the Hague Institute for the Internationalisation of Law's new trend report called Rule Jungling. By contrast, I noted with interest that Harold Coe, throughout his lecture, cited many examples across the spectrum of international cooperation, and in each and every case, he made it absolutely clear whether he regarded the outcome as international law or as something else. Clearly that distinction is very important to him, both as a State Department legal practitioner and as an academic. The distinction also matters in a very practical way at the interface between international and domestic law. So, for example, in a state where, under the Constitution, a treaty must be submitted to the legislature before it can be ratified, somebody has to decide whether a particular document is a treaty. And somebody has to decide whether its provisions need to be implemented in domestic law, and if so, whether the legal authority to do so exists. And if those decisions are later challenged in court, then the court has to decide one way or the other. Those decisions have very practical consequences, and so does making a mistake. And so I believe there's useful work to be done to clarify how the distinction between binding and non-binding rules is being made, by whom, when and why. And we need to look at what this tells us about the future development of international law. So this is one of the themes we intend to explore in our first wave of research projects under the Watts programme. To illustrate this, I'd like to mention two of our current projects. The first one is a project to carry out training and research on treaty practice, on which we're collaborating with the Centre for International Law at the University of Singapore. Our joint aim is to formulate universal criteria for good treaty practice that can be used by any states and international organisations, and to illustrate them with a wide range of examples from around the world. We hope that when we publish our conclusions, this will be of practical benefit to those who deal with treaties, especially those establishing a treaty office for the first time in a new state or organisation, and also of academic interest to a much broader readership. Now, by treaty practice, I mean the procedural aspects of dealing with treaties, the nuts and bolts of treaty practice, and not just the legal framework within which it's conducted. Good treaty practice tends not to attract attention. I think its importance is easier to explain by reference to what can go wrong. So here are a couple of simplified real-life examples. If a government doesn't have an accurate record of all the treaties it's a party to, then how can it be in compliance with its treaty obligations? If a government fails to ratify a treaty in the correct manner, it may discover years later that the treaty isn't in force or it isn't a party to it. If this sort of error comes to light as a result of international litigation, it can be expensive as well as embarrassing for the government concerned. It can also have a serious impact on individuals, especially where human rights or investment treaties are concerned. And there are a number of real examples that have affected the position of investors that can be seen in the cases reported on the BIICL website. So now to return to the current project. We held an international workshop on treaty practice in Singapore for legal officials from the 10 member states of the Association of Southeast Asian Nations, known as ASEAN, and the Secretariat of ASEAN. There's very keen interest in this subject among the ASEAN states, especially those in the process of building new democratic institutions. And the ASEAN Secretariat is actively engaged in developing its own treaty practice in order to strengthen ASEAN as a rules-based organisation. So we had some very interesting discussions on the traditional ASEAN approach to treaty making and whether it needs to change in light of their current objectives, whether to use binding and non-binding agreements, when to use binding and when to use non-binding agreements, when and how to use reservations, and difficult questions about transparency and whether secret treaties are ever permissible, and if they're not, what governments can do if they want to conclude binding deals on confidential matters. A set of recommendations designed to improve treaty practice in the Southeast Asian region emerged from the workshop, and if you'd like to see them, they're on the Institute's website and the Centre's website as well. So all of these dialogues and perspectives will help to shape the outcome of our study and our eventual recommendations for good treaty practice. Now, the other new project of the WATS programme that I'd like to mention to you today concerns governance and jurisdiction in the continent of Antarctica. The Antarctic Treaty is a subject which has fascinated many international lawyers, Arthur and myself included. We both had the privilege of representing the UK at Antarctic treaty meetings and of visiting Antarctica on government business. Arthur wrote what is still 20 years on one of the leading works on the subject. And it isn't just for his diplomatic and academic achievements that Arthur's made history. He also has a claim to fame as the orchestrator of the southernmost game of cricket ever played. He took part in an international workshop at a field camp near the South Pole. And he told me that before they arrived there, he hatched a plan with the New Zealand delegation. He persuaded them to bring a set of cricket bats with them. And then during dinner, I think while everyone was just finishing their coffee, Arthur just called out casually across the tables, "Anyone for cricket?" And that was the signal for the New Zealanders to suddenly produce the set of bats, and everyone went rushing outside. And that's how it happened. So the Antarctic Treaty, 1960, was one of the world's first disarmament treaties. It also provides the framework for environmental protection and international cooperation on scientific research in the region, so crucial to understanding global climate change. And its relevance is very close to home, with a new Antarctic bill currently making its way through the British Parliament. The Antarctic Treaty has kept the peace for over 50 years, but it left a number of problems of jurisdiction and enforcement unresolved. This was brought to the fore recently when a group of French yachtsmen went sailing around the Antarctic Peninsula without any permit and decided spontaneously to pitch up on shore on the coast of the Antarctic Peninsula and have a party. So they got drunk, they needed some place to kip for the night, they broke into a British historic hut, they lit a fire, and they went to sleep. Well, next morning the Frenchmen woke up and sailed away. Despite the best efforts of the French authorities, however, they still haven't been brought to justice, despite the fact they were caught red-handed damaging the hut. Apparently, the evidence was refused by the French courts due to doubts about the legal status of the territory where the incident took place and the source of the legal authority of the officials who produced the evidence. Well, this incident, of course, was rather minor in terms of actual damage, but other much more serious examples of the failure of law enforcement in Antarctica do occur. And with the steady increase in tourism and scientific activities, the spectre of a serious oil spill from an ocean-going cruise vessel, for example, looms on the horizon. The Antarctic Treaty parties have started to, or rather agreed to start discussing jurisdictional issues at their next meeting. So they've had talks about talks so far. Talks are supposed to start at the coming meeting, but for governments to get to grips with such matters is actually very difficult because of diplomatic sensitivities and also lack of information about how other governments go about implementing treaty obligations in their domestic legal systems. None of these constraints apply to us at the British Institute of International and Comparative Law. We're independent and we have a team of research fellows and interns from all over the world, qualified in their own legal jurisdictions. So we're ideally placed to examine how the various parties to the Antarctic Treaty understand their role in the Antarctic and how they've implemented their legal obligations in their respective domestic legal systems. The Environmental Protocol to the Antarctic Treaty is coming up to its 25th anniversary. So this is a very opportune time to review how effective it is on the ground and its jurisdictional gaps, contradictions and overlaps. And we hope that our research will make a significant contribution both to knowledge and to making it work better. And perhaps also to considering how well suited the Antarctic Treaty is as a model for solving disputes elsewhere in the world, such as the Arctic and other regions where resources are in dispute. Well, I hope this evening has given you an insight into some of the work that we're doing and plan to do as part of the fellowship programme established in Arthur's memory. There are a number of other activities ongoing and for the future, which you'll be hearing more about shortly and in the fullness of time. One of these is our forthcoming book on the law of the sea, for which Vaughan has kindly agreed to write the foreword. As Frank mentioned, linked to the Watts Fellowship, there's a new institutional relationship with the Melbourne Law School. This has seen the creation of a series of Arthur Watts visiting fellowships and internships, and we're delighted that two of them are in the room with us this evening. And also the prospect of collaborative research projects between our two institutions. So we're very excited about this development and what it might entail for the future. I'm also pleased to announce that Voltaire Fietta have kindly agreed to sponsor the first Arthur Watts Public International Law seminar series. This series will start on the 30th of April with the first event at which Sam Wordsworth, Colin Warbrick and Stephen Fietta will address the theme of public international law in the courts of the United Kingdom. Details will be on our website very soon. Finally, I'd like to say how grateful we all are for the support and good wishes of everyone here this evening. It's so nice to see so many old friends in the room as well as our new ones. On behalf of all future Arthur Watts Fellows, as well as myself, I'd like to thank our advisors, donors, sponsors and friends for helping to secure the future of public international law at the Institute and for linking it indelibly with the memory of a man so widely admired and liked in our legal community.